Hi, welcome everyone. I'm Eric Ramanathan, Executive Director of the Program on the Legal Profession. Thank you all for coming today. We spend a lot of time at the program thinking about the various roles that legally educated folks can play. And obviously many of you are probably thinking about how you might interact with boards of directors in your careers as lawyers, as critical advisors to boards in the nonprofit or for-profit sectors. But there's an equally important role for lawyers actually populating these boards of directors. And very few people know as much about particularly nonprofit boards as our speaker today, who counsels and supports a 75-person board of directors as Vice President, General Counsel, and Secretary of the Lincoln Center for the Performing Arts in New York. And so we're extremely privileged today to have Lesley Rosenthal with us to talk about that.
Great. Thanks so much, Eric and Professor Wilkins. It's delightful to be back. I say back only in quotes because this is a new room, but
nothing this nice when you were here.
Nothing this nice. These big, scary classrooms with cavernous echoes, and I was so intimidated. I came through at the age of 21. I graduated from Harvard College in 1986 and just traipsed across the way and landed here in September of '86, and really had no idea what I was letting myself in for, and I mean that in a lot of different ways. After law school, and I knew I wanted to be a public interest lawyer, I went and I clerked for Judge Shirley Wohl Cram, now deceased, in the Southern District of New York. And as I was starting to think about my next job after the clerkship, she said, "You know, Lesley, you really ought to go to a law firm." And at that time, I really had absolutely no interest in going to a firm. I had not interviewed at firms. And the law school at that time, and I don't know if it's different now, had a real kind of us and them mentality among the students and even among the professors. To some extent, there was like the public interest, strap on your Birkenstocks, you have taken your vow of poverty and you are down with the common man, or you're a corporate tool, there is no redemption for you. Any ideals that you ever had, you can just kiss goodbye to because you're going into a law firm and that's going to be the end of you as a whole human being. A number of years in private practice where I did eventually land at the judge's good suggestion really helped me see that there's a lot of ways to bring those worlds together and to do good and do well all at the same time, or seriatim. So I guess one of my themes here today is to help give you an avenue, even while you're launching your careers and perhaps going to a law firm, to find a way to serve the nonprofit sector in a really meaningful way. The law firm that I landed up at was Paul Weiss, Rifkin, Wharton, and Garrison. I went there for one reason and one reason only, and that is because they had the largest number of junior to mid-level associates traipsing through my judge's courtroom on pro bono matters, and that's why I went. True to form, they permitted me to do an awful lot of pro bono projects, including for 5 Tibetan Buddhist monks whom I helped to get political asylum, for a juvenile, through the Juvenile Rights Division of the Legal Aid Society of New York, to help her get out of foster care where she was languishing for 8 years and to be adopted by the foster parents who had raised her all that time. A number of matters for volunteer lawyers for the arts, and most significantly for the purposes of my present role as General Counsel of Lincoln Center, I was asked by my college roommate, who's a modern dancer, if I would come to a fundraiser that they were having for this brand new shoestring modern dance company that she was helping to form, called the Doug Elkins Dance Company. And so I bought 2 tickets to the fundraiser. They were $40 a piece. That made me their single largest donor to date. And once they got to know me a little bit, they asked if I would both join their board and be their general counsel, both of which were extremely flattering. I think I was 25 at the time, and I really had very little idea what a general counsel did, and even less idea what the board member of a nonprofit organization did, and certainly very little idea about how those two might interact in ways that are synergistic and ways that are potentially problematic. So I learned my way the hard way. Interesting issues came up pertaining to they needed to have disability insurance for their employees, and how do they procure that? And so I learned how to research that for them. They started to go up in the world, and instead of dancing in these kind of downtown studios, they were invited to dance at the Joyce Theater, which is a huge break for them, and the Joyce Theater's contract engaging them to perform there required that they clear the music to which they were dancing. They had no idea how to do that, so that fell to me also. Fortunately, the firm was willing to provide a supervising attorney, a very important element of both pro bono service and really any work that you're doing on behalf of a nonprofit in an early stage of your career. A few years later, a larger and more sophisticated nonprofit called Child Care Action Campaign that had an institutionalized board. The Mailman Foundation was represented. There was a senior editor of Time, Inc., and a number of others were on that board. And they had heard that I was the pro bono general counsel and a board member of this dance company, and they asked if I would play those roles for the Child Care Action Campaign, which I was delighted to do, and learned even more about the variety of legal needs and also more about the governance structure and capacity of a larger, more sophisticated nonprofit organization. So that when 13 years passed, much to my chagrin, and I was still at the firm, and the opportunity came up to apply for a job at Lincoln Center, a job which I deeply desired. I'm a violinist, my husband's a pianist. The arts are just like infused in every element of our family. I just had to get that job. And there was only so far that I was going to be able to get by citing the litigation experience that I had had representing large publicly held companies in securities fraud litigations or real estate arbitrations or international deals that had fallen apart and had gone to litigation. And so I trotted out some of my experiences for my pro bono matters, including having the roles as outside pro bono general counsel to two nonprofit organizations. And it ends up being like, you know, these little pearls, and you stitch them together, and you know, eventually they form a necklace, and was able to persuade the president and ultimately the board at Lincoln Center that I was the person for the job. And have been just delighted to serve and learn in that role. Really three roles. I'm a vice president, which means that I have a business title and role. I'm the general counsel, which means I need to retain that professional independence that comes along with being a lawyer. And I'm also the corporate secretary, which gives me a real bird's eye view into the governance of the organization. So with that introduction, I'd like to move on to what lawyers and law students can do on a nonprofit board. And I want to just start by asking, how many of you are involved with a nonprofit organization in some way now, as a volunteer, as a donor? So several. And within 1 degree of separation, how many of you have either a friend or a family member or neighbor or somebody else who's involved with a church group, with a hospital, with a soup kitchen, with an environmental organization, with an arts and cultural organization? And hopefully that's just about everybody. Okay, so these are the circles in which you already travel, and with your legal education and background, there is a really important new set of roles that you could play. So what are some of the things that board service can do for an attorney? You can contribute meaningfully to the mission of an organization. And a mission is what a nonprofit has instead of shareholders. So nonprofits are not owned by anybody. Nonprofit's a little bit of a misnomer because it's perfectly okay for a mission-driven organization to make a profit. It just means you have an excess of revenue over expenses. That can be a sign of good management. The difference is what you do with the profit. Instead of flowing it up to your shareholders as dividends who get to put it in their pockets and become wealthier, you're pouring those profits back into the organization for further mission realization. So that's what makes a nonprofit a nonprofit. And the opportunity to serve on a board means that you can contribute meaningfully to the mission of that organization. And the board is primarily responsible for the governance of that organization, meaning oversight of management into how that mission gets realized. So you're learning business skills at the same time, and I use business in a looser sense than the P&L type of business that we might be thinking about in a corporate law class. So organizations that are serving healthcare related needs, for example, have a business model that basically has fees coming in for services rendered. And there may be also a smaller sliver of contributed income from foundations, from corporations, from individuals who are grateful to that healthcare organization. But primarily their business model is going to be about earned revenue. As opposed to, say, a cultural organization like mine, where it may come as a surprise to some folks who think that ticket prices are already too high, to find out that the prices of the tickets aggregated really cover generally less than 50% of the actual cost of producing that event. And so where does the other 50% come to? Do we just run deficits year after year after year? No, obviously that's not sustainable. What we do is have a very robust program of fundraising from corporations and foundations and individuals to top up the operating budget every year. So it's an opportunity when you're on a board to learn about the business model of a nonprofit organization, and by extension you're learning about the business model of all kinds of different organizations as well. So it's a way of stretching your skill set. There are opportunities to really interact with people at a different generation than yours, which I found to be incredibly valuable when I was a young person serving at the board of these larger and more institutionalized organizations. Professional networking. You might even have the opportunity to show what you know and show what you can do to a fellow board member who's influential in a profit-making organization. And they may think to hire you to serve a role similar to what you're serving for the nonprofit. Now, you wouldn't want to go into a nonprofit board service with the idea that you're going to be profiting or making legal fees off of that organization. That rarely works out well because one of the legal constraints on a nonprofit organization, and this is true of all 50 states' nonprofit corporations law as well as the federal law that is situated in the Internal Revenue Code, is that there must not be private inurement of the people close to the organization. So that means the officers and directors must not be privately profiting or being inured by the activities of the organization. That's not to say that the management can't be properly compensated for their work as executives, but there are real strictures on how much executives can be compensated in the nonprofit world in order to make sure that the excess of what their market value is and what they're actually getting paid, that would be considered a private inurement. So there are ways in which lawyers sitting on boards can really help an organization understand how its management, how the management of the organization fits in with the whole legal structure, context, and surround. I did bring an article that I had posted to the Harvard Corporate Governance blog. I encourage you to grab a copy on the way out that really articulates some of the basic legal fiduciary duties and governance aspects. There's a personal element as well, maybe even more personal than like professional networking and showing what you know, and that is when you land at a law firm, you can oftentimes feel like a small cog in a big wheel. And it can be very depersonalizing. And when you're sitting in a boardroom, all of a sudden you become a valued member of the team. Your individual contributions are adding to the good of the whole. You could help shape the outcome of a new business initiative or a strategic plan, or take pride in spotting a risk that they didn't see coming and helping steer them towards mitigating it. Now, are you going to be giving the legal advice to go in there and actually do the mitigation work? Probably not. And if you do, and we'll get to this shortly, you want to flag that there's this line of demarcation. You've taken off your hat as a member of the board and you're putting on your hat as counsel to the organization. In some states that requires an engagement letter, even if it's on a pro bono basis. And if you don't do that line of demarcation, you could find yourself in a major difficulty with for example, the insurance company that provides directors and officers liability insurance, which would cover your actions as a board member, is going to be pointing to your legal malpractice carrier, which covers your activities as a practitioner, and nobody's going to really want to cover the fallout if something goes wrong, leaving you exposed. That is not a place you want to be. You can also end up inadvertently creating a waiver of privilege issues if you don't clearly demarcate when you are speaking as a lawyer as opposed to when you're speaking as a board member. So I wanted to just raise those cautionary elements to you. Sometimes that tail, the cautionary tail, wags the dog of the opportunity to serve on a nonprofit board. In fact, when I was preparing to give this talk and others like it, all the articles that I found were all the scary stuff that, reasons why lawyers shouldn't join boards. There may be a heightened level of knowledge imputed to a lawyer. There may be greater exposure. There may be opportunities for conflict of interest and for privilege waiver and for scope of uncovered activity. Yes, but the vast majority of times you're really going to be contributing in a very beneficial way to yourself and to the organization, and it's a good idea to keep in mind these other potential risks as well. So, what's in it for the organization? I want to help you visualize this from the organization's perspective, because I'm going to ask you at the end to think about actually approaching an organization after this session and after maybe you've had a chance to do a little bit more reading, and offer yourself as a prospective board member or a member of a junior board that's being groomed eventually for the governance role. So what do they want out of you? Any participation here? Anybody want to start us off? Why would a board want to bring you on as a director?
I'll just steal your word and pick up on participation. Somebody who's going to be involved and show up to meetings and make a contribution.
Exactly. Somebody's going to be involved, show up to meetings, and make a contribution. And although that may sound a little obvious on its surface, it's actually profoundly important. There are fiduciary duties that board members have. In the state of New York, there's 3 of them. In other states, there's 2. And they are very much in common with the fiduciary duties of board members of for-profit corporations as well. Fiduciary duty number 1.
They want to be associated with your credentials and your connections.
Oh, definitely true. Let me come back to that in a second. Fiduciary duty number 1 is the fiduciary duty of care. And every board member has it. In every state of the union, in every corporation that they sit on the board of. So, and the fiduciary duty of care, thing number 1 is show up at meetings, read the minutes, participate in the life of the board and the organization, know what's going on, understand its business model, read its financial statements. I can't stress enough the importance of that. And I have sat in on board meetings of organizations that have literally asked the question, if we bring in somebody really rich or famous, do they have to come to board meetings? Yes, they have to come to board meetings, because being rich is a wonderful thing, and if you want to make a contribution to a charity of your choice, God bless you, they can all use it, and they will make wise use of it, we hope. But that is not a substitute. It's not like one of those indulgences in the Middle Ages where you can like buy your way out of attending board meetings. You must go to board meetings. You must pay attention. And if you're so fortunate to have Mikhail Baryshnikov be interested in your shoestring modern dance company, that's really wonderful. But if he's going to be too busy to actually come to board meetings and pay attention to the activities of this organization, then don't put him on your governing board. Put him on your honorary board, or put him on your artistic board, or put him on your advisory board. But don't put him on your governing board if he can't carry out the fiduciary duty. Okay, what's the other fiduciary duty? Stewardship. The fiduciary duty, as it's stated in the textbooks, is the fiduciary duty of loyalty. And that means that you need to put the institution's interests ahead of your own, your company's, your family's, or anybody else when you are acting as a board member. So you don't go and refer that contract to provide telephone services to the dormitory of your college whose board you sit on to the phone company provider that you hold a 49% shareholder interest in. That would be a classic breach of the duty of loyalty. That is not a fake example. In New York, there is a third duty that's been stated in the case law. It's not yet been codified in the statute books, and it's the fiduciary duty of obedience. Anybody want to take a guess what that is? It sounds so like, you know, don't be disobedient. But anybody? Yeah?
Does it mean you have to abide by the decisions of the board?
You have to abide by the laws that pertain to the nonprofit organization, and you also have to abide by the nonprofit organization's own internal governance structures, its bylaws, its articles of incorporation, its mission statement, and so on. And when you add those three together, you land up with this just real urgent sense that the resources of that organization need to be devoted to the pursuit and realization of its mission. And if you can keep that in mind, if you're the Jiminy Cricket who's sitting on that board and just taking every decision with that in mind, you'll be doing an enormous service to the board, and you will be bringing a legally comprehensive and relevant perspective to the board that frankly a lot of them may be missing. I wanted to talk about professional kind of burnishing the board's roster. Is that what you were? I didn't get the phrase that you said, but I think I have the concept of it. Yes, boards definitely love to have people with a high stature in the community, and that's you. That can help attract funders. It can help attract interest in the organization and its activities. It can help attract other board members of a similar caliber. So don't underestimate your ability to really help the organization leverage your presence. They are interested in having your legal expertise and perspective, and that might actually lead to a little bit of role strain that I wanted to explore with you a bit. I have had any number of good-hearted friends who were lawyers join nonprofit corporate boards because they really want to help. An elder care lawyer, for example, joining the board of a senior hostel. And a legal issue arises, and all eyes turn to her. And she's like a deer in headlights because she could recite elder law to you chapter and verse, but like, you know, this real estate problem or a whistleblower policy or a contract for an event planner, it's really so far out of her comfort zone. And the board thinks, oh, you're a lawyer, you're on the board, we have a legal question, boom, you know, we're all done. So it's really important on the way in to really set expectations and monitor those expectations. That's not to say that you don't have an extremely valuable role to play in helping spot legal issues, and there are very natural categories that those legal issues fall into. Some of them pertain specifically to the nonprofit's status as a nonprofit. Some of them pertain to business law matters that we're all pretty familiar with in ordinary business dealings. And as I like to say to nonprofit executives when I give talks to them, just because you're tax exempt doesn't mean you're law exempt. And they're like, oh, but Lesley, we're doing the Lord's work. You know, why do I have to comply with the ADA or the Foreign Corrupt Practices Act or the building codes? Well, yes, Virginia, you do. All of those apply to your organization as fully as if you were a profit-making organization. So we lawyers can be very helpful in spotting those kinds of legal issues as well. We can also be helpful in sourcing legal advice, whether paid or pro bono, giving them some leg up on which firms might be interested in handling this matter and qualified to do so. Having a lawyer approach a lawyer, especially for pro bono services, really helps in like the credibility of the pitch. We will also have a much better understanding of how big of an ask this is. So having done pro bono work on and off for 13 years while I was in private practice, I can now tell you within an hour, estimating how much time one of my pro bono projects is going to cost the next law firm that I ask to help. I can say, we need this project over the next 2 to 3 weeks. It's going to require about 2 hours of your supervising partner's time and maybe 10 hours of time of the junior associate working on this. And when you structure the assignment that way, they're so much more willing to take on the work for you on a pro bono basis than if it's like this open-ended blank check kind of thing. So your knowledge and your credibility, and even if it ends up being a paid engagement, you're having given them 3 or 5 law firms that can handle this kind of work, and being at the table when they interview those firms to take on the work is going to really keep that lawyer in a very disciplined way in terms of stating what the scope of work is and stating what the likely fees are going to be. Maybe even you could challenge them to come up with a project budget that's going to be reasonable and manageable for the organization. So we can share our legal knowledge, but stop short of actually providing the legal services, and that can be one thing that we bring to a corporate board. We are sometimes pretty good facilitators, pretty good negotiators. I think back on Roger Fisher's negotiation class literally on a daily basis and find ways of expanding the pie and getting to yes and all of that. Those are great skills to have on a nonprofit corporate board and that you can bring to bear for the good of the organization. Your connections, your other civic engagements and activities can also really help the organization. If you know local political figures or officials and might be able to help connect the organization to sources of visibility, sources of new clients, sources of funding, public funding, etc., all really great roles for lawyers to play for nonprofit organizations. There are some donors that require certain levels of good governance on a board. They are literally looking to check the box. Do you have an audit committee? Who retains the outside auditor? What's your policy for establishing executive compensation? Do you have a whistleblower policy? Right? And you being a lawyer on the board, you can help the organizations navigate these questions and get them to the right answers, that the funder feels really great about writing that next grant check to your organization, and also maybe helping to manage a little bit what those expectations are. So another story, a friend of mine represents a music conservatory upstate New York, and a few years ago the IRS started requiring you to disclose on the informational return, the Form 990 that all nonprofits have to file, whether or not your organization has a whistleblower policy. And this conservatory did not. So my friend wrote one up for them. And it got Xeroxed and folded up and put in the envelope and dispersed to each of the department chairs. And the chair of the string department opened up the envelope and they see the whistleblower policy, scratch their heads, fold it back up and stick it in the envelope with a note that says, "I think you meant to address this to the head of the wind faculty." So I'm not saying that you should be writing the whistleblower policy if that's not your area, but you could really play a valuable role if you were sitting on the board of that conservatory to help teach and guide management about what these mysterious legal things are and help them maybe with the educational function, with the rollout of these policies so that they're not scratching their heads over the next mysterious policy. Maybe further to your point a little bit as well, there's legal matters that arise not necessarily from a regulatory point of view, but a business-to-business point of view, a landlord-tenant matter, a breach of contract matter, and so on, that having a lawyer on the board, just your presence alone, has kind of an interorum effect against people that might be tempted to try to take this nonprofit organization for a ride. So there's lots of reasons why they want you. But we haven't gotten to the one that they probably think you're the best for that you might not be that comfortable with. And that's fundraising. So just about every nonprofit board that I know of has what they call a give or get requirement. And that means that there's a level of expectation, whether it's a few $100 or a few $1,000 or more than a few $1,000, that each and every board member is going to participate in either providing charitable contributions to the organization or asking your friends and business colleagues to contribute to that organization, all of which would add up to your satisfaction of the give or get expectation. So if you're asked to join a board, or if you're doing a little due diligence about what that board might be expecting of you, you need to ask that question. What is the expectation of financial participation? Especially if you're a student coming out of school, and if you were like me, you had loans up to your ears. You just want to make sure that there isn't some assumption on their part, oh, you went to Harvard Law School, you must be, you know, bankrolled by Daddy Big Bucks, that expectation is surfaced and discussed. Some organizations are happy to have their give or get be satisfied by donating at a level that's meaningful to you. And that's between you and your conscience, and you take care of it that way. Some organizations are happy to have your in-kind contribution. That means you roll up your sleeves and you're working, you're providing the benefit of your labor. That can be very meaningful as well. But I didn't want this part of our talk to have that expectation go unstated. I wanted to talk a little bit about due diligence. What kinds of things do you think that we lawyers should ask to look at, or ask for information or seek information about when we're considering an offer to join a nonprofit board?
Should probably ask for their founding documents and their bylaws.
Absolutely. You need to get their articles of incorporation and need to get their bylaws. You probably also want to get their application for tax exempt status and any amendments that might have come about for any of those documents. What else?
You want their financials?
Definitely. You want their financials. You want their audited financial statements if they are audited, or unaudited if they are not. And you may want them going back a few years. And further to that end, maybe you also want their budget book, so that you can really understand what they spend money on and where that money comes from in a pretty granular way. And that also leads me to understanding their business model and finding out if they have a strategic plan. And if they have a strategic plan, it's so important that you get your hands on it, because the board helped to envision that document, and it's really the board's responsibility to make sure that it is implemented. So yeah, those would really be the key documents. You also want to make sure that you attend events in the life of the organization, and that you circulate and get to know people. As kind of social as that might sound, it's an important way to really fulfill that fiduciary duty of care, to be intimately involved in the life of the organization and to understand its people well. So now I promised you that we would get into some details about specifically how lawyers can serve meaningfully on a board. And some areas that I want to bring to your special attention are, does the organization, for example, have a governance committee? Or is it in the middle of rewriting its bylaws? These are great places for you to get involved and really help the organization visualize its ongoing governance structure. Is there a public affairs or a government relations committee? Great place for lawyers who are policy and politics minded. Is there an audit committee? Don't be afraid of being on the audit committee. It sounds like a lot of stuff that people in business school might be more interested in, but it's really all about checks and balances. It's really all about making sure that the person who's writing the checks isn't the same person who gets to add payees to the authorized list. And it can be a really great place for you to contribute to a nonprofit's good governance. If there's a legal committee, that's a pretty obvious one. If there isn't a designated corporate secretary, or if the taking of minutes seems to be a pretty informal or desultory affair, I would encourage you to volunteer yourself for that duty. It's unglamorous. It's undersung, but it's really, I think, one of the most important elements and markers of good governance of a nonprofit organization is somebody keeping good minutes of what happened at the board meetings, what decisions were raised, what was the discussion about, and what decision was ultimately taken. And there's some art and judgment to it as well, which we hope we're pretty good at as lawyers. You don't want to be like literally a scribe, like one of those court reporters taking transcription, because that can chill the conversation in a boardroom. And what you really want is open and full discussion of the important matters in front of the organization. So a little bit of finessing about what was discussed and who took what position, while still accurately reflecting what decisions were taken at that meeting is in order. So think about a corporate secretary role. There's a wonderful nonprofit lawyer. She's a partner at a major New York law firm. She teaches here, I think, on the faculty. Victoria Bjorklund, a wonderful attorney. She has a PhD in medieval studies, a very broad-ranging person of great interests, who was asked about 20 years ago to join the board of a then up-and-coming organization called Doctors Without Borders. And she found a way to really make that experience meaningful for herself, because she always wanted to learn more about marketing. So she wasn't like sitting there down and dirty with the bylaws committee, although she easily could have done so, but really stretched herself as a person through her board service and got herself on the marketing committee. And their job at hand was to create a new logo for Doctors Without Borders. And she said she remembers sitting there, you know, sketching out ideas and designs for the logo, which ultimately got adopted and is still in use to this day. Oh, and by the way, they won the Nobel Prize in 1999. Not saying it was because of the logo, but you know, there's lots of ways of really expanding your own vision and really coming around to seeing yourself as a contributing member of a board in ways that are beyond the narrow legal function. So I want to leave a couple of minutes for questions. I touched on some of the kind of technical matters that you need to be aware of. I'll say them one more time because I'm acutely aware of Professor Wilkins' presence in the front row. He was my legal profession professor back in you-know-when. So the ABA and the model rules do not expressly prohibit lawyers to act both as counsel and as a board member. That's one thing that you need to know, and it's Rule 1.7 of the ABA model rules that sets forth the basic conflict of interest provision. A lawyer may not represent a client if such representation involves a concurrent conflict of interest. And then there's a comment to this rule, comment 35, that discusses lawyers serving on their corporate client's board, and it does not prohibit it. There are also state and local ethics opinions that you should familiarize yourself with depending on the locality of the organization you're thinking of serving. They urge caution, but they also recognize the propriety of lawyers sitting on the corporate boards of clients. Unlike accountants, by the way, who are just flatly prohibited. The conflict of interest doctrine is an interesting place to focus your attentions if you like to tease out these tensions. The ABA Formal Ethics Opinion 98-410 identifies possible conflict of interest situations for lawyers acting as directors. I mean, it gets a little squirmy when you're advising the board to do one thing and then they ultimately end up voting to do something else. Right, so that's this ethics opinion explores some of those issues about whether the lawyer is being asked to pursue objectives of the organization that, as a director, the lawyer opposed. There are other conflict of interest scenarios, as you can well imagine, and particularly in the area of a controversy between the organization and its lawyers, or a controversy between the organization and one of the other clients of the law firm. So you want to just be really aware of those potentials, especially if you're at a large firm. Keep that stuff top of mind. If your firm is charging the organization, that opens up a whole new area for conflict of interest scenarios, as well as private, enormous private benefit that you want to be aware of. You want to be clear about when you're acting as lawyer and when you're acting as director, so that there isn't an inadvertent waiver of the attorney-client privilege. And I commend to your attention Model Rule 1.6, mandating that a lawyer shall not reveal information relating to representation of a client. And you want to, again, clearly identify when a legal relationship has been established, and then avoid misunderstandings about what happens in that boardroom when you are rendering legal advice to the board, and denote the privileged character of that advice in that context. The third area I wanted to bring to your attention is in insurance. You're protected from lawsuits as a director by the organization's D&O, or directors and insurance. Directors and officers insurance policy. You're protected from malpractice by your professional malpractice liability policy, but they love to try to shift the burden of defending and indemnifying you to somebody else. And so you don't want to get caught up in a situation where there's a gap in coverages, and that's another reason to be crystal clear about what role you're playing and when. I am going to stop there and take a couple of questions. Oh, and I was going to pass copy of my book around.
Yes, I was going to say, I was going to plug it if you didn't.
All right. You could do that too.
Yeah.
It's called Good Counsel, Meeting the Legal Needs of Nonprofits. I wrote it last year and it was published in January. And there's an awful lot about the range of legal needs, as well as a number of case studies, several of which were written by colleagues of yours at Harvard Law School. And it's really written from a very practical perspective to help people get their arms around what the legal issues are for nonprofit organizations. The received wisdom, and what the headhunters will tell you, is that you must be either a tax or a transactional lawyer. You must not be a litigator if you have any hope of becoming a general counsel. So anyway, the headhunters have been known to be wrong before, but that's the received wisdom. I would encourage you to pursue the latter course that you were describing, of just maintaining as general a perspective as possible. I mean, if you go way down the road of like trademark enforcement, you know, that maybe 2 or 3% of what I do all day is trademark enforcement. It's relevant, but it's not really the big picture. Really also encourage you to pursue what makes you look well and do well. So if you're passionate about whatever it is, you're going to really blossom as an attorney, and that's what's going to bring you to the attention of somebody who might want to hire you as a GC. It's a hot topic and getting hotter by the minute. The IRS finally came out with a 3-prong rebuttable presumption for executive compensation. Are you ready? I can recite them off the top of my head. One of them is to have an independent compensation committee of the board. And when I say independent, I mean that the person whose salary is being considered must not be on that committee, nor should a family member of theirs or somebody else who has a business relationship with them. And then second, that independently constituted compensation committee of the board should be looking at comparable salaries of other executives performing a similar role at a similar type of organization. And you can do that informally for a smallish organization by looking at those Form 990s of other peer organizations and keeping your eye on the listings like in the Chronicle of Philanthropy or Crane's Business about what nonprofit executives get paid in the various fields. Or you could hire a compensation consultant. Believe it or not, there's a whole cottage industry now of people that just collect all this industry data and can help situate your executive at the 50th percentile, the 75th percentile, who are their peer institutions, etc. That can really help you come up with a figure that is going to be meet the rebuttable presumption of the IRS. And then the third thing, lawyers, hello, get your ears out here. Remember I was talking about the corporate secretary role? Somebody needs to be taking minutes of that meeting of the compensation committee of the board so that there's been due documentation of that discussion process and make sure that it's all been rendered in writing so that if the IRS ever comes to audit, which they are now in a very active cycle of doing now on this very issue, you've got a record of the independence of the committee and the other comparables that were studied. There are some organizations that will be looking for people who have achieved a certain level of experience. And so for those, you might want to put them kind of into your medium range plan as opposed to something you could do tomorrow. Those same organizations, if they're well run and well governed, will have a feeder board or a junior board. And you could start out by, for example, volunteering to help manage an event for them or to host an information session about what they do or some other volunteer project like that and really get on their sites. There are other organizations that are more startup-y or more geared toward young people that would be delighted to have you at your present stage and age. So just think about the mission of the organization and how your background and things that you've already done really connect to what it is that they're trying to accomplish in the world. There's a couple of resources I want to point you to. One is BoardServe NYC, for those of you who are bound for New York. It's part of the United Way, and they are actively connecting people that want to sit on nonprofit boards with organizations that are looking to build board capacity. There is a group called Board Assist, and there is another group run out of the Ford Foundation called the Foundation Center. The Junior League is also focusing obviously on cultivating younger people. So I would recommend those resources to you.
Can I just plug one other resource we have here, which he's too modest to say himself, but Eric Ramanathan is on many nonprofit boards, and actually he might say to you, one way to join one is to start one, which he also started a nonprofit organization while you were in law school, is that right? Or shortly thereafter?
Shortly thereafter, yeah.
Shortly thereafter. So, although Lesley sadly will fly away, and I'm actually going to take her away, because actually, as some of you know, who will follow us, she's been kind enough to join me in talking in my class, but Eric is here, and a great resource for thinking about nonprofit boards. So if any of you are interested, I hope
Great. And then one last plug while we're all plugging.
Yeah.
I do hire 2 summer legal interns. Generally, they are rising 2Ls who are willing and able to spend the summer in New York with us, working on all manner of legal issues at Lincoln Center, and a job description is here.
Any other, I mean, we still have, if you're willing to
I'm happy to, I'm guided by you.
I promise her a break because, you know, we're working here very hard, so union rules or she needs a break. But if there's one last question, and then you have any thing, or maybe we'll just thank Lesley, and then if some of you want to talk informally.